This case is partly interesting because of the language used. It's startling to see the casual racism used even at the highest levels of international law just 100 years ago. The case arose from a new tax imposed by the government of Great Britain upon the local people in the colony of Sierra Leone in Western Africa. Those local people revolted against the tax. As the arbitration tribunal put it, as is common in the more uncivilised parts of Africa, it was marked by every circumstance of cruelty and by undiscriminating attacks on the persons and properties of all Europeans. Among those Europeans were a group of Americans called the Home Frontier and Foreign Missionary Society of the United Brethren in Christ. They ran a number of missions in areas where the uprisings occurred. Their missions were attacked and some of the missionaries were killed. The British responded with force. The tribunal said, under peculiarly difficult and trying conditions, they did their duty with loyalty and daring and upheld the highest traditions of the British Army. Once the rebellion was put down, though, the Missionary Society asked the government of Great Britain to pay compensation for the damages caused by its colonial subjects. Britain refused, and so the government of the United States got involved on behalf of its citizens. The question was whether Great Britain could be responsible for harm caused by people who were actually causing violence in opposition to the British government. The tribunal said, it is a well-established principle of international law that no government can be held responsible for the act of rebellious bodies of men committed in violation of its authority, where it is itself guilty of no breach of good faith or of no negligence in suppressing insurrection. In fact, the tribunal found that the missionaries had knowingly accepted the risks. The Missionary Society must have been aware of the difficulties and perils to which it exposes itself in the task of carrying Christianity to so remote and barbarous a people. The contempt for difficulty and peril is one of the noblest sides of their missionary zeal. The tribunal found that no compensation was payable, but it urged the government of Great Britain to voluntarily pay compensation anyway. From this case, we confirm that a national government is not vicariously liable for harm caused by insurrectionists seeking to overthrow that government.